In this lecture, we shall discuss the service of processes generally. The service of processes generally. And we shall have this discussion within the context of the civil procedure rules as applicable in Ghana. Civil procedure rules that are applicable in Ghana. Now, to begin this lecture, there are a number of points that have to be noted. The first point is that after an action is commenced, for example, if a plaintiff commences an action by way of a writ of summons, and that plaintiff must serve a defendant with the process. Remember, after you have issued the writ of summons, you have to ensure that the defendant is served with the process before the proceedings will continue. Now, how would the defendant be served? The first point you must note is that if you must serve a document on the defendant, the rules require that generally service of a document must be personal. What it means is that you must ensure that the document is delivered and handed over to the person against whom the process has been issued. So that, for example, if a writ of summons has been issued, you must go with the bailiff, show the bailiff who this defendant is, and let the bailiff serve the person personally by giving it to him. That is what we mean by personal service. It means that you don't give it to his brother, you don't give it to his relative, you don't give it to his wife. You hand over the process to the defendant personally. Now, any document which is required to be served on the person must be served personally unless the rules provide otherwise or unless the court otherwise directs. I have mentioned over here that the service of a process, it must always be personal, meaning that you must hand it over to the person personally. But as you can see from the second point that I just read, that any document which is required to be served on a person must be served personally unless the rules otherwise direct or unless the court otherwise directs. It means that there are some circumstances under which the rules can permit a person to be served in a manner which will not be personal service. So you must take note that the rule I have mentioned, that every person is supposed to be served personally, it's only a rule that is the general position. But there will be some exceptions where the rules will require that a person can be served in a manner which will not be personal service. But for now, bear in mind that all processes may be served on the party personally, or when the party is represented by a lawyer, the process may be served on the lawyer. Service on the lawyer shall be deemed to be service on the party. In other words, if you, the plaintiff, you have commenced an action, and you commence an action by a writ of summons, you have served the defendant. Now the defendant wants to serve you, the plaintiff, with a process, let's say a statement of defense or a counterclaim. Because you, the plaintiff, you commence an action by a lawyer, the process can be served on your lawyer. And when it is served on your lawyer, it shall be deemed that the process has been served on you, the plaintiff. In the same vein, if a defendant has entered appearance, now future processes may be served on the defendant's lawyer that entered the appearance for him. So if I have sued you, a defendant, and you have engaged a lawyer who has entered appearance on your behalf and has given us his address, for future processes, I can serve those documents on the lawyer. And it will be deemed that because he's the lawyer that entered appearance for you, it will be deemed that service was properly made. So generally, service of a document must be personal. This means that the document must be delivered and handed over to the person against whom the process has been issued. Generally, any document which is required to be served on the person must be served personally unless the rules provide otherwise. Now, because the rules provide otherwise in some circumstances, we'll look at instances where companies, for example, how do we serve them? We'll look at those instances. Now, the next point you must notice that where the person on whom the document has been addressed is an artificial entity, such as a company. When the person to whom the document has been addressed is an artificial entity, such as a company, the document must be served in accordance with the provisions of Section 291 of the Companies Act 992. Where the person to whom the document has been addressed is an artificial entity, such as a company, the document must be served in accordance with the provisions of Section 291 of the Companies Act of 2019, Act 992. It means that if you want to serve a company, you must comply with the provisions of Section 291 of the Companies Act 2019, Act 992. I'm not going to read it now, but you should, at this point, open Section 291 of the Companies Act and see what it has said about service of processes on companies. But I'll revisit it in this lecture. So this is just by way of introduction, and so we shall proceed to begin with what do the rules say? What are the provisions in the CI 47 as far as service of processes is concerned? So we shall proceed with beginning with service of processes under Order 7 of the CI 47. So take a look at Order 7 of the CI 47, which is the High Court Civil Procedure Rules 2004 CI 47. This is what Order 7 Rule 1 says. Order 7 Rule 1, and I read, it is headed person to serve a document. Person to serve a document. Now, it says that a document which is required to be served, a document which is required to be served on the person shall be served by a bailiff of the courts or a process server registered with the courts, but a party may direct the service. What does this mean? Again, a document which is required to be served on the person shall be served by a bailiff of the courts or a process server registered with the courts, but a party may direct the service. What does this mean? What this means is that if I, as plaintiff, I have issued a writ of summons. Now, when I get to the registry and I issue the writ and it's against only one defendant, I'm likely to be given 3 copies. One for myself, the one will be for the courts, which will be with the courts, and don't give that to me. And the other would be the one the bailiff would have to go and serve the defendant with. Because if I've commenced an action against you, you have to be served so that you will be aware that I have commenced an action against you. Now, the rule is telling us that as plaintiff, I don't go myself and hand over the writ to the defendant. No, I don't go and defer the service. The service has to be carried out by a bailiff of the courts or a process server registered with the courts. So this is what you must look at. It shall be served by the bailiff or a process server registered by the court. So you want to know who serves the writ of summons. Sometimes somebody will ask, if you issue the writ, so who is supposed to serve the writ of summons? According to Order 7 Rule 1, a document which is required to be served on a person shall be served by a bailiff of the court or a process server registered with the courts. But a party may direct service. What do you mean by a party may direct the service? It means that even though the bailiff is the one who is supposed to serve, I, as a plaintiff, I can go with the defendant. Because the bailiff may not know who the defendant is. He may not know where he lives. So I go with the bailiff and I point at the defendant. I'm directing that this is the defendant called Kwesi and serve him. So as a party, I can direct the bailiff on who we should serve. But I cannot go and serve myself. It's the bailiff who at all material times would have to serve the process. Now look at Order 7 Rule 2. It deals with personal service. Remember, I've already mentioned something about personal service. Now, let's look at what Order 7 Rule 2 of the CI 47 says. It reads as follows, and I quote, it is headed personal service. Order 7 Rule 2, Sub Rule 1, and I read, A document which is required to be served on the person shall be served personally unless the express provisions of these rules otherwise provide or the court otherwise directs. A document which is required to be served on the person shall be served personally unless the express provisions of these rules otherwise provide or the court otherwise directs. End of quote. So if anybody asks you, what is your authority for saying that a document must be served on the defendant personally, refers to Order 7 Rule 2, Sub Rule 1, that a document which is required to be served on the person shall be served personally unless the express provisions of these rules otherwise provide or the court otherwise directs. So if service is effected in any way which is not personal service, the people must show that the court has given a direction to that effect. If the court hasn't given any permission for them to serve you in a different way, or the rules have not given them the provision or the permission to serve you in a different way, then every service on you must be personal. That's why you will soon see that when we get to things like substituted service, it is because the rules will provide and give them permission to serve you by substituted service. That's why they can do it. Because the court will have ordered. But you as plaintiff, you can't wake up on your own and say that I have tried to set the defendant. I couldn't set the defendant, so I'm going to post the writ on his house. No. Before you effect service in any way which will not be personal service, the rules must give you the express provision or the court must have given you the express direction. So now Order 7 Rule 2, Sub Rule 2. This rule shall not affect the power of the courts under any provision of these rules to dispense with the requirement of personal service. So take notes. If anybody asks you, what is your authority for saying that a document which is required to be served must be served on the defendant personally? It's Order 7 Rule 2. But remember Order 7 Rule 1, where we mentioned that the person to serve a document must be the bailiff. And remember I mentioned that you, the plaintiff, you can't go ahead and go and serve yourself. What we said that as plaintiff you can do is that you can direct service. But the service has to be done by the bailiff. Now the next question I want to ask is this. Why must the service be done by the bailiff himself? Why must the service be done by the bailiff himself? Now think about it. We are in court litigating. As plaintiff, I am saying that the writ has been served on you, the defendant. And the writ is such serious business that if you are defendant, you don't enter appearance. As plaintiff, I can apply to the court to get default judgment against you. But the question is that if I go to the court and then I want to apply for default judgment against you, what is the proof that I have indeed served you, the defendant? Should the court take my word? If I'm the one that went to serve myself, how will the court take my word for it? So the court wants a neutral person who has to be carrying out the service and who will report to the court that on this day you gave me this writ of summons and I went ahead to serve the defendant with it. So the reason why the bailiff must serve is that the bailiff will have to prove service indicating the person on whom the document was served, the time and date served, and at which place the document was served. Or when necessary, the bailiff will have to fill or depose for an affidavit of non-service. Non-service means that the bailiff was not able to serve the documents. So whenever a bailiff goes to serve a process, he would have to go and prove service. He will have to go and prove service, saying that, and that is telling the court that on this day, you court, I was given a writ of summons, and then I went ahead to serve the defendant at this particular place, at this particular time, and I gave it to him personally. So that proof of service is going to be on the judge's docket. So if you bring an application or you are in court and the judge wants to find out whether the defendant has been served the document, he will look at his file and you'll see the proof of service over there. And the proof of service will indicate the person on whom the document was served, the time and date and the place that the person was served at. If the bailiff was unable to serve the defendant or any person, the bailiff will fill or depose an affidavit of non-service. An affidavit of non-service means that you say that I was given this writ of summons, I had to serve the defendant, but I could not serve him. So it will be an affidavit of non-service. That you have sworn an affidavit that there have been a non-service of the writ of summons. How is personal service effected? If you have to serve a person personally, how do you effect the personal service? The answer will be under Order 7 Rule 3, Sub Rule 1 of the CI 47. It says that personal service of a document shall be effected by leaving a duplicate or attested copy of the document with the person to be served. So like I've said already, you go to the defendant, you are the one that I have been told to come and serve. This is meant that you hand over the document to him. That is how personal service is supposed to be effected. Like I mentioned earlier, you don't effect personal service by leaving the document at the church, leaving the document for his sibling, leaving the document for his wife. You carry out personal service by handing over the document to the defendant personally. That is how we carry out personal service. But what if the person who is supposed to be saved, what if he refuses to be saved? What if he get there and he says, don't get close to me? He get there and said, don't come close to me. I'm not going to accept this document. And he's threatening to slap you or things. As a bailiff, you want to serve a person and the person is hindering you, the bailiff, from serving the person. He tells you, don't get close to me or else I'm going to open the doors for you. If you come close to me, I'm going to slap you. He's threatening you. What if the person to be served refuses service or prevents service in the normal way or hinders the bailiff through threats or violence from serving the person? What happens? Because we've been told under Order 7 Rule 1 that, Order 7 Rule 3, Sub Rule 1 that service of a document shall be effected by leaving a duplicate or attested copy with the person who is supposed to be served. This is the case where the person is refusing service, preventing service in the normal way. What will happen? Can you throw the document on him and run away? What if you throw it on him and he doesn't look at it? Can you just leave the copy on his car and run away? And what will be the effects of that kind of service? The answer to this question, look at Order 7 Rule 3, Sub Rule 2. Order 7 Rule 3, Sub Rule 2. Order 7 Rule 3, Sub Rule 2. This is what it says, and I quote. Where personal service of a document on any person is hindered by violence or threats or other acts of obstruction of that person or any other person with or under that person, it shall be sufficient for the person effecting service to leave it as near that person as may be practicable. It shall be sufficient for the person effecting service to leave it as near that person as may be practicable. It shall be sufficient for the person effecting service to leave it as near that person as may be practicable. What this means is that as a bailiff, you are going to serve a defendant. He is threatening you with violence or other acts of obstruction. You are saying that it shall be sufficient for you, the person effecting service, to leave it as near that person as may be practicable. So if you throw it on him, even though he hasn't taken it himself, that should be deemed to be proper service. Because you've left the document as near that person as may be practicable. So the bailiff, when they're going to prove service, would have to write that on this day I was entrusted with a writ of summons. I was supposed to serve the defendant. When I got there, he hindered me through threats of violence. So I threw it and then the document touched his body and then fell on the ground and it was close to him. The bailiff will have to prove the service, indicating how he went ahead to serve it, so that we know that that's how the service was carried out. Now, that will be sufficient personal service of the process. So don't think that if the people come and they want to serve you, you are going to run away. If you try to run and they throw it on you and they come, it gets as close to you as possible, that will be deemed to be personal service. So that's Order 7 Rule 3 sub Rule 2. It says that where personal service of a document on any person is hindered by violence or threats or other acts of obstruction of that person or any other person with or another person, it shall be sufficient for the person effecting service to leave it as near that person as may be practicable. So this is how personal service is supposed to be effected. So for what we've done so far, we are saying that by the rules, a document which is required to be served has to be served by the bailiff or a process server registered with the courts. We have said that by the rules, personal service, that a document which is required to be served on a person, that document shall be served personally unless the rules are giving you any permission to serve in any different manner. But generally, every document must be served personally. And we have seen why the bailiff must be the one effecting the service. He will have to go and prove service, indicating the person on whom the document was served, the time and date served, and the place at which the document was served. And like I've said, if the bailiff was unable to serve, he will have to depose to an affidavit of non-service of the process. How do we effect personal service? Like I have said, you effect personal service by leaving a duplicate or attested copy with the person who has to be served. What if the person refuses service or prevents service in the normal way? Remember Order 7 Rule 3 sub Rule 2. Where personal service of a document on any person is hindered by violence or threats or other acts of obstruction of that person or any other person with or under that person, it shall be sufficient for the person effecting service to leave it as near that person as may be practicable. Now, the next question is that there are some particular entities that you cannot serve them personally, or that the rules will provide that you must serve them in different ways. Now, for the rules, we have to find out, how do we serve a person with disability? Remember on number 5, there are some people that we describe as persons with disability. How do we serve such people? If you want to serve a stool, a skin, you want to commit an action against a stool, how do you effect the service? If you want to effect service on a head of, you are suing a head of family, how do you sue that person? How do you serve that person? If you have to serve a company, how do you serve such entities? If you have to serve a partnership, how do you serve them? So because of this, it means that we have to go ahead and then identify how these different entities have to be served. And I'll begin with serving partners. So service to be effected in actions by or against partners. If you want to serve a partner, how do you carry out the service? The answer to this will be under Order 6 Rule 3 of the CI 47. Order 6 Rule 3 sub Rule 1 of the CI 47. It reads as follows, and I quote: where by virtue of Rule 1, partners are sued in the name of a firm, the writ may, except as specified in sub Rule 2, be served A, on any one or more of the partners, or at the principal place of business of the partnership within the jurisdiction, on any person who has at the time of service the control or management of the partnership business there. Again, where by virtue of sub Rule 1, where by virtue of Rule 1, partners are sued in the name of a firm, and I'm reading Order 6 Rule 3 of the CI 47. Where by virtue of Rule 1, partners are sued in the name of a firm, the writ may, except as specified in sub Rule 2, be served A, on any one or more of the partners, or at the principal place of business of the partnership within the jurisdiction. So, where by virtue of Rule 1, partners are sued in the name of a firm, the writ may, except as specified in sub 2, be served A, on any one or more of the partners, or B, at the principal place of business of the partnership within the jurisdiction, on any person who has at the time of service the control or management of the partnership business there. Then Order 6 Rule 3 sub Rule 2, it reads as follows, and I quote, where service of the writ is effected in accordance with sub Rule 1, the writ shall be deemed to have been duly served on the firm, whether any member of the firm is out of the jurisdiction or not. Again, where service of the writ is effected in accordance with sub Rule 1, the writ shall be deemed to have been duly served on the firm, whether any member of the partnership is out of the jurisdiction or not. Now look at Order 6 Rule 3 sub Rule 4. It reads as follows. We are dealing with how a service will be effected in actions by or against partners. Order 6 Rule 3 sub Rule 4. Every person on whom a writ is served under sub Rule 1 shall at the time of service be given a written notice as in Form 2 in the schedule, stating whether the person is served as a partner or as a person who has control or management of the partnership business, or both as a partner and as such a person, and any such person on whom a writ is served but to whom no notice is given shall be deemed to be served as a partner. What this means is that every person on whom a writ is served under sub Rule 1 shall at the time of the service be given a written notice, and the notice they will give you would indicate whether you have been served as a partner or you have been served as a person who has control or management of the partnership. Remember that under Order 6 Rule 3 sub Rule 1, we were given 2 ways in which we can serve a process when you commence it against the partnership. 2 ways. Look at the A, on any one or more of the partners, or B, at the principal place of business of the partnership within the jurisdiction on any person who has at the time of service the control or management of the partnership business there. It means that you can either serve on any one or more of the partners, or you can serve on any person who has at the time of service the control or management of the partnership business there. Now we are being told under Order 6 Rule 3 sub Rule 4 that every person on whom that writ is served under sub Rule 1, that person shall at the time of service, you have to give the person a written notice as in Form 2 in the schedule, stating whether the person is served as a partner or you serve the person as a person who has the control or management of the partnership business. Or you indicate whether you serve them both as a partner and as a person who has such control. And any person that you don't give that notice to shall be deemed to have been served as a partner. So when you are commencing an action against a partnership, you don't just go and serve in any way. You must comply with this particular procedure under Order 6 Rule 3. Next is to identify how a person with disability is served. How do we serve a person with disability? That is the next to be discussed. So for a person with disability, the procedure of serving such a person has been spelled out under Order 5. So I would go ahead and read Order 5 Rule 1, Sub Rule 1, and explain who a person with disability is. Then I'll proceed to read out the provision that relates to the manner of serving such persons with disability. So Order 5 Rule 1, Sub Rule 1, it reads as follows. For the purpose of judicial proceedings under these rules, So we have been told that a person with disability for the purpose of judicial proceedings under these rules as meaning a person under the age of 18 years or a person who is certified by a medical officer to be incapable of managing and administering his or her property and affairs by reason of mental disorder or infirmity of mind. For the purpose of judicial proceedings, we are describing a person with disability as a person under the age of 18 years or a person who is certified by a medical officer to be incapable of managing and administering his or her property and affairs by reason of mental disorder or infirmity of mind. Then we have Order 5, Rule 1, Sub Rule 2. It says that the court may, where it considers it desirable, in any action, order a medical examination of the person claimed to be a person with disability. Then Order 5, Rule 1, Sub Rule 3, it reads as follows, and I quote, subject to these rules, anything which in the ordinary course of any proceedings is required or authorized by these rules to be done by a party to the proceedings shall, if the party is a person with disability, be done by his or her next friend or guardian ad litem. Again, subject to these rules, anything which in the ordinary course of any proceedings is required or authorized by these rules to be done by a party to the proceedings shall, if the party is a person with disability, be done by his or her next friend or guardian ad litem. Then Order 5, Rule 1, Sub Rule 4 says that a next friend or guardian ad litem shall act by a lawyer. So we've been told under Order 5, Rule 1, who a person with disability is. We've been told that such people can only commence an action through their next friend or guardian ad litem, and the next friend or guardian ad litem must also act by a lawyer. Now, how are such people supposed to be saved? Order 5, Rule 9 of the CI 47. Order 5, Rule 9 is headed Service of Documents on Persons with Disability. Order 5, Rule 9, Sub Rule 1. Where in any cause or matter a document is required to be served personally, and the person on whom it is to be served is disabled, the document shall be deemed to have been served if served on the father or mother or guardian of the person disabled, or the person with whom the disabled person resides or under whose care the disabled person is. What I'm saying is that we have been told that a person with disability is a person under the age of 18 years, or a person who is certified by a medical officer to be incapable of managing and administering his or her property and affairs by reason of mental disorder or infirmity of mind. Now, if we want to use that the person who the law describes as a person with disability, how do you serve the person? We have been told that where in any cause or matter a document is required to be served personally on, and the person on whom it is to be served is disabled, I mean the person is below 18 years, or the person has been certified by a medical officer to be incapable of managing and administering his property. The rule is saying that Order 5, Rule 9, where in any cause or matter a document is required to be served personally, and the person on whom it is to be served is disabled, the document shall be deemed to have been served if served on the father or mother or guardian of the person disabled, or the person with whom the person disabled resides, or under whose care the disabled person is. Then Order 5, Rule 9, Sub Rule 2. Notwithstanding anything in Sub Rule 1, the court may order that a document which has been or is to be served on a person with disability or on a person other than a person mentioned in that sub-rule shall be deemed to be duly served if served on the person with disability. In other words, even though we've been told under Order 5, Rule 9, Sub Rule 1, that if you want to serve a person with disability, you can serve his father or mother, or his father or mother or guardian, we have been told that even though these are the people that you can serve, if you want to serve a person with disability, the court may order that a document which has been or is to be served on a person with disability or any other person mentioned under sub 1 shall be deemed to be duly served if served on the person with disability. So in other words, in appropriate circumstances, the court can actually order that a document should be served on the person with disability himself. Then order 509 sub 3, notwithstanding anything in these rules, a judgment or order that requires a person to do or refrain from doing an act, a notice or application for the committal of any person, and the writ of subpoena against any person, shall, if that person is a person with disability, be served personally on that person unless the court otherwise directs. So that's how you serve persons with disabilities. Order 509, sub 1 and 2 would be helpful to tell you that when in any course of matter a document is required to be served personally and the person on whom it is to be served is disabled, that document shall be deemed to have been served if served on the father or mother or guardian of the person disabled, or the person with whom the disabled person resides. That is how you can serve the document. But notwithstanding this, the court may still order that a document which has been or is to be served on the person with disability shall be duly served if served on the person with disability. The court can give that particular order. But if you want to serve an order of the courts or committal, not a notice of committal against a particular person, who is the person with disability, we've been told under order 509 sub 3 that you shall serve personally the person with disability unless the court directs otherwise. What about service on particular persons, as you see under order 705? You remember I had mentioned that how do we serve stools, cane, body corporates, and the like. So order 705 is headed service on particular persons, and this is what order 705 sub 1 says. Because of its import, I'm going to read out the entire order 705, and then from there we shall analyze into detail what it says in essence. Order 705, service of a document on a body corporate may, in cases for which provision is not otherwise made by any enactment, be effected by serving it on the chairman, president, or other head of the body, or on the managing director, secretary, treasurer, or other similar officer. Now take a critical note of the wording of order 705 sub 1. Says service of a document on the body corporate, so for example, a company. But the instructive provisions you see over there are in cases for which provision is not otherwise made by an enactment. So if there's no enactment that has prescribed a particular procedure for serving a body corporate, that is when you come under this order 705 sub 1. Take a critical look at order 705 sub 1. Service of a document on a body corporate may, in cases for which provision is not otherwise made by an enactment. So it's only when there's no provision in any enactment, that is when you can serve it on the chairman, president, or other head of or other body or managing director. That is when you can serve it in that particular way. But if there's a provision in any enactment, well, that's when you cannot serve it in a different way. You must comply with what the enactment is saying. So with companies, as you will soon see, Section 291 of the Companies Act has given a procedure for serving companies. It means that the provision in order 705 sub 1 will not kick in because there is a provision in an enactment showing how we should serve companies. So even though order 705 sub 1 is saying that service of a document on the body corporate may, in cases for which provision is not otherwise made by an enactment, be served in those ways. In this case, as of 2024, in fact, from 2019 coming downwards, there was an enactment that dealt with service of companies. Even before then, the old Companies Act, it also had provisions on serving companies. This is what Section 291 of the Companies Act of 2019, Act 992 says. is headed Service on Companies, and I read. A document may be sent on the company by A, leaving it at, or sending it by post to, leaving it at, or sending it by post to the registered office of the company, or the latest office registered by the registrar as registered address of the company. B, sending it to the official electronic mail address of the company, registered with the registrar. And C, sending it by facsimile machine to a telephone number used by that company for the transmission of document by a facsimile. So that is section 291 of the Companies Act. It has given provisions on how we should serve documents on companies. So the Order 705 sub-1 that says service of a document on a body corporate may, in cases for which provision is not otherwise made by an enactment, be effected by leaving it on the chairman, president. Those ones will not kick in because we have a provision, which is an enactment that has laid down how we should serve companies. So section 291 of the Companies Act is very critical in letting you understand how we should serve companies. So read section 291, subsection 1, read subsection 2, subsection 3, subsection 4, which is very critical. Look at subsection 4 and 5. Subsection 4 says that where the registered office of a company cannot be traced, service on the director of the company, or if a director cannot be traced in the Republic, on a member of the company shall be deemed to be good and effectual service on the company. So if you can't find the address, maybe the address with the register of companies, when you go there, you can't find them there. When you see any director of the company he's serving, it will be deemed to be service on the company. And if you can't see any director in Ghana, if you serve it on any member of the company, it shall be deemed to be good and effectual service. Then section 291, subsection 5 says as follows. Where it is proved that a document was in fact received by the director, managing director, or company secretary, the document shall be deemed to have been served on the company, despite the fact that service may not have been effected in accordance with subsection 1, 2, 3, or 4. Where it is proved that a document was in fact received by the director, managing director, or company secretary, the document shall be deemed to have been served on the company, despite the fact that service may not have been effected in accordance with subsections 1, 2, 3, or 4. What I have done is that if you look at Order 705, it's telling you that you shall only serve in accordance with Order 705 when there's no provision made by any enactment. But in this case, when there's an enactment, an act of parliament, Companies Act, that has specified how we should serve companies, that is the procedure you must comply with under section 291 of the Companies Act. This is a very critical provision, so you must make sure that you read Order 705 sub 1 and section 291 of the Companies Act. If you don't read this, you will not understand the case of Barclays Bank of Ghana Limited versus Ghana Cable Company Limited. This is a very critical case as far as service on companies is concerned. So, Barclays Bank versus Ghana Cable Limited versus Ghana Cable, Barclays Bank of Ghana Limited versus Ghana Cable Company Limited and others. Reported in 1998-1999 Supreme Court of Ghana Law Report at page 1. This is a very critical case on service. This case actually explains critical portions of service and how it even relates to appearance. So you must pay particular attention to what we are about to deal with in this. In fact, it is very important. So I have to take my time to walk you through the entire portions and relevant portions of the case. Now, this is what happened in the case of Barclays Bank of Ghana Limited versus Ghana Cables Company Limited and others. Let me give you an insight before we go into it. Let's say a company has been sued the wrong person has been served, but the lawyer enters appearance for that company. And now eventually the case goes on and judgment has been given against that company. Meanwhile, the wrong person was served. Can the fact that a lawyer entered appearance for all of the company, can it actually mean that the company has waived the right to be served properly? Now, with this in mind, let us look at the facts of Barclays Bank of Ghana Limited versus Ghana Cable Company Limited. This is what happened. On the 23rd of March, 1989, the plaintiff bank issued a writ of summons against the defendants for inter alia the sum of 24,454,985 with interest, being the loan granted to the first defendants and guaranteed by the 5 other defendants, 3 of whom were limited liability companies. The endorsement by the bailiff on the writ of summons only indicated that the writ was served, unquote, on the defendants through their company secretary, Madam Alice, into bracket FA, at the office. Again, the endorsement by the bailiff on the writ of summons only indicated that the writ was served, and I quote, on the defendants through their company secretary, Madam Alice, at their office. And a notice of appearance was purportedly entered on behalf of the defendants by a firm of solicitors, Chris, Brown, Edu, and Muntumi, on the 12th of April, 1989. Subsequently, the plaintiff bank took out summons for final judgment and order 14 of LN 140. At the hearing of the summons, the lawyers for the defendants appeared for the defendants. And on 25th May 1989, the court, with the consent of the lawyer, entered judgment for the plaintiff bank for the amounts claimed with costs. Let me explain what is happening so far before I move on. So the bailiff has endorsed that the writ was served on the company secretary, who the bailiff referred to as Madam Alice, at the office. An appearance has also been entered into by lawyers who appeared in court, and judgment was given against the defendants. Now let's see what will happen. On the 14th of January 1994, almost 5 years after this judgment, the defendants filed a motion at the High Court, Accra, for an order to set aside the final judgment entered on 25th of May 1989, on the ground that none of them was served with the writ of summons, and consequently, that the court had no jurisdiction to enter judgment against them. Again, on the 14th of January, almost 5 years after the judgments, the defendants filed a motion at the High Court for an order to set aside the final judgment entered on 25th May 1989, on the ground that none of them was served with the writ of summons, and consequently that the court had no jurisdiction to enter judgment against them. But the question I want to ask is that we have been told already that the company was served through the company secretary. So why are they saying that they were not served? When we read ahead, we'll understand. In an affidavit sworn by the said defendants in support of the motion, the defendant deposed inter alia that at the time the summary judgment was entered, the said defendant was in detention at the behest of the Provisional National Defense Council and was indeed not served. And further, a search they conducted at the High Court Registry revealed that the 4 limited liability companies were served through MA as their secretary. The defendant also contended with the support of documents from the Registrar General Department that their secretary was Lenap and Company and not Madam Alice. And therefore, Madam Alice had no authority whatsoever to receive service on their behalf. So you see, the defendant have brought a set saying that Madam Alice was never a company secretary. And so if you served there, you served the wrong person. So the person that you served was the wrong person. So the lawyers also were instructed by the wrong person to enter appearance on behalf of the company. So the defendant also contended that the person they served, Madam Alice, was not their secretary. And she was also not instructed to receive documents on their behalf. On 12 May 1994, the High Court, differently constituted, refused the application to set aside the final judgment for the reason that Madam Alice might have held herself out as secretary to the bailiff. So the High Court dismissed the application to set aside the final judgment on the ground that Madam Alice may have held herself out as secretary to the bailiff. And that's why the bailiff went ahead to serve Madam Alice. So think about this. The defendants are saying that Madam Alice was never a secretary, so he said the wrong person. The High Court judge held that Madam Alice might have held herself out, even the word is might have held herself out. And that's what the bailiff said, Madam Alice. Dissatisfied with the ruling of the High Court, the defendant appealed to the Court of Appeal, which by its unanimous decision reversed the High Court's ruling on 12 May 1994 and set aside the final judgment entered against the defendants on 25th of May 1989. Whereupon the plaintiff bank filed the instant appeal to the Supreme Court on grounds that the Court of Appeal erred in setting aside the final judgment and misdirected itself on the legal effects of the entry of appearance by solicitors or parties in the suit. At the hearing of the appeal, counsel for the plaintiff bank forcefully contended in support of his case that the Court of Appeal failed to appreciate that the real issue in dispute was whether the solicitors who entered appearance for the defendants had authority to enter the said appearance. Let me explain what is happening here. The lawyers for the plaintiff are saying that if you are saying Madam Alice was not a secretary, what you must realize is that since lawyers entered appearance for you, the defendants, then they must have been instructed properly to have entered appearance for the defendants. So the judgment is supposed to stand. But you know what the argument of the defendants will be? Defendants are saying that, my friend, whoever you said Madam Alice, she was not a secretary, and you have not given her any instruction to receive processes on our behalf. Let us proceed. So the lawyers for the plaintiff contended, and I quote, that the legal effect of entering an appearance was to give jurisdiction to the courts to grant any appropriate relief against the party on whose behalf appearance was entered. And remember, the appeal has been lost by the plaintiff to the Supreme Court because at the Court of Appeal, the defendants won when the whole judgment was set aside. Now, there's an appeal to the Supreme Court by the plaintiff. It was held dismissing the appeal that the final judgment obtained by the plaintiff bank under Order 14 of LN 140 was in all the circumstances of the case a nullity. And the defendants were consequently entitled to have same set aside ex debito justitiae for the following reasons. Again, the final judgment obtained by the plaintiff bank under Order 14 was in all circumstances of the case a nullity. And the defendants were consequently entitled to have same set aside ex debito justitiae for the following reasons. A. Under the rules of procedure, every writ of summons or any process initiating a legal action had to be personally served on the defendants in accordance with law, unless the solicitors of the defendants undertook in writing to accept service on behalf of the defendants or the courts, taking into account the exigencies of the case directed otherwise. Again, under the rules of procedure, every writ of summons or any process initiating a legal action had to be served personally on the defendants in accordance with law, unless the solicitors of the defendant undertook in writing to accept service on behalf of the defendants or the court, taking into account the exigencies of the case directed otherwise. Proceedings against a party were deemed to commence only after the service of the writs or notice of the writs on that party. And when personal service proved unsuccessful, substituted service might be resorted to. Furthermore, unless a defendant had been served no process could be taken to obtain judgment against him. For until such service, the court was generally not seized with jurisdiction to proceed against the unserved defendants. Again, proceedings against a party were therefore deemed to commence only after the service of a writ or notice on that party, and when personal service proved unsuccessful, substituted service might be resorted to. Furthermore, unless a defendant had been served, no process could be taken to obtain judgment against him. For until such service, the court was generally not seized with jurisdiction to proceed against the unserved defendants. The court continued, and I quote, "In respect of a company with a registered office or registered address, Section 2631 of the Companies Code 1963, Act 179. And bear in mind, this was because as of 1998, that was the act that was in force. So this case was decided under the Old Companies Act. So I read again. In respect of a company with a registered office or registered address, Section 2631 of the Companies Code provided that a document might be served by leaving it at or sending it by post to such an office. And on account of the provisions of Section 2631 and 2 of Act 179, the letter containing the document should be addressed either to the registered office or the latest office registered as the registered office of the company. Prepaid and posted early enough to ensure that the letter was received in such time as to enable the company file the relevant papers within the time provided by the procedural rules of court. However, where the service of the document was not by post, but by leaving it at the registered office or registered address as provided in Section 2631 of Act 179, the bailiff, even though Section 2631 talked of leaving it at, had to leave the document with some responsible person who was in the position to bring it to the attention of the company. This is very important. Let me read it again. However, where the service of the document was not by post, but by leaving it at the registered office or registered address as provided in Section 2631 of Act 179, the bailiff, even though Section 2631 talked of leaving it at, had to leave the document with some responsible person who was in a position to bring it to the attention of the company. Thus, taking the cue from the provisions of Section 2631 of Act 179, as to the categories of persons on whom service was deemed to be good service, a document left with a director or the managing director, or the secretary or a member of the company at the registered office or address should be sufficient service of the company within the expression leaving it at in Section 2631 of Act 179. On the evidence on the instant case, there was no dispute that the said defendant, a human being, was not at all personally served with the writ of summons, as he was then in detention, and there was no order for substitute service through Madam Alice. And in the case of the other defendants who were limited liability companies, the endorsement by the bailiff on the writ of summons showed that the writ was served in Accra on the defendants through their company secretary, Madam Alice, at their office. Yet, the unchallenged evidence on record clearly showed that Lenap and Company was the secretary of the defendants, not Madam Alice. Hence, the service on Madam Alice was clearly unauthorized and void, as in clear violation of the provisions of Act 179. In effect, the defendants were all not served in law, and the person on whom the writ was served had no vestige of authority to accept same. Again, hence the service on Madam Alice was clearly unauthorized and void, as in clear violation of the provisions of Act 179. In effect, the defendants were all not served in law, and the person on whom the writ was served had no vestige of authority to accept same. So the court has concluded from this case so far, as you can see, that because Madam Alice was never authorized by the company to in fact accept the writ of summons, and also the service was not done in accordance with the Companies Act, the court has held that the defendants were all not served. But let's move on to the next part. Remember, the plaintiffs argued on the legal effect entered of the appearance entered by the lawyers. That if a lawyer enters appearance, it should mean that then he must have obtained some instruction. This is what the court said. The entry of appearance by a solicitor would only raise a rebuttable presumption, not a conclusive presumption, that the defendant had been served with the writ of summons. Besides, the general principle was that where a solicitor entered appearance on behalf of a defendant without authority, neither the court nor the solicitor on the other side had the obligation to inquire whether his authority to do so indeed existed. However, the defendant had the right to set aside any subsequent judicial process taken against him on the representation of the solicitor. In the instant case, it was clear on the evidence that the law firm which entered appearance on behalf of the defendants did so without proper authority. Hence, the purported appearance too was a nullity, and the defendants had the right to set aside the final judgment based on the unauthorized entry of appearance. In the circumstances, the purported entry of appearance could not be deemed to be service in law in the defendants. Now, what do we get from this case? What we get from this case is that the Madam Alice that was served and described as a company secretary, she was not in fact the company secretary. She had not been instructed to receive any process. So whatever was said on her was void. Now, if it comes to the lawyer's entry in appearance, would the entry of appearance by the lawyers mean that the lawyers were instructed by the company? The court held that if the lawyers entered appearance, it means that it will be a rebuttable presumption. We will presume that before a lawyer will enter appearance, he has been instructed, but that presumption is rebuttable. As in this case, where it has been shown that the person who received the writ was not a secretary, she was never instructed, and so if she has also gone to instruct some lawyers, it means the lawyers will never also have any instruction from the right person. So the presumption would then be rebutted. So the entry of an appearance raises a rebuttable presumption that the defendant has been served, but that presumption can be rebutted by the evidence on the record. So this is actually flowing from Order 7, Rule 5, Sub Rule 1, which deals with service of a document on the body corporates. You read from Order 7, Rule 5, Sub Rule 1, mention that in this case there's an enactment dealing with the service, read section 291, then show that these same words were in the old enactment. Then you can go to a case of Barclays Bank versus Ghana Cable. This case emphasizes the crucial requirement of service. Because the right person wasn't served, the whole judgment was set aside. That is why it is important for you to understand how documents are saved. This case will let you know that if you are commencing an action, you must be careful in who you serve, because if you serve the wrong person, after several years, so long as you didn't serve the right person, your whole judgments can be nullified. That is the crucial essence of Barclays Bank of Ghana Limited versus Ghana Cable Company Limited. Because once you didn't serve the right person, the whole judgment, even after 20 years, you can nullify it. So this is actually flowing from Order 7, Rule 5, Sub Rule 1. Let's look at the other sub rules of Order 7, Rule 5. Order 7, Rule 5, Sub Rule 2 deals with service of a document on a stool or skin. On a stool or skin. It reads in this wise: service of a document on the stool or skin may be effected by serving it A on the occupant of that stool or skin, or any secretary, clerk, or linguist of that stool or skin, or where the stool or skin is vacant, on the regent or caretaker of the stool or skin. Next, Order 7, Rule 5, Sub Rule 3. Service of a document on a family as constituted by customary law may be effected by serving it A on the head of family, or B on any member of the family who is or is acting as caretaker of any property of that family, or any person who is a principal member of the family. That's how you serve a document on the family as constituted by customary law. What if a person is in detention? Order 705, sub 4. Service of a document on a person who is in prison or detention may be effected by serving it on any person apparently in charge of the prison or place of detention, or if access cannot be readily had to the person apparently in charge of the prison or place of detention, then any warder, guard, or similar officer of that prison or place of detention. So read all the other provisions under Order 705. Another one deals with service on the Minister of State and your service on a person with disability. Those are all very critical things you must take note of. So these Order 705 deals with service on particular persons. We've seen how you can serve a company. We've seen how you can serve the occupant of a stool. We've seen how you can serve a family as constituted by customary law. We've seen how you can serve a person who is in prison or detention. What about serving on a Minister of State, Order 705, 705? Serving on a Minister of State in his or her capacity as such, or a ministry or government department, may be effected by serving it on the administrative head on that ministry or that department. Then Order 705, 706 says that service of a document on a person with disability may be effected in accordance with Order 509, which we've already dealt with. So this is what deals with service on particular persons. Since we've already exhausted everything about Barclays Bank versus Ghana Cables, we shall move on to substituted service. What do you mean by substituted service? Order 706 reads as follows. If a document is required to be served personally on any person, and it appears to the courts that 3 or more attempts have been made without success to effect personal service, and that any further attempt to effect personal service may result in undue delay, or that it is otherwise impracticable for any reason to serve the document personally, the court may make an order for substituted service of that document. So if, for example, we have to serve a person personally, and we are looking for you everywhere we can't find you, we are looking for you, we can't find you, and we can show that we've made at least 3 or more attempts to effect personal service, and any further attempt to wait for personal service may result in undue delay, we can apply to the courts for an order to serve you by substituted service. Or if we can show that it's otherwise impracticable for any reason to serve you personally, the court can give us permission to serve you by substituted service, so that we can come on the land and post the document on the land. The moment you post it that way on the land, or we serve you to Daily Graphic, or we serve you via WhatsApp or Facebook, in law, that will be deemed to be service on you, and we can proceed against you. So if a document is required to be served personally on any person, and it appears to the courts that 3 or more attempts have been made without success to effect the personal service, and any further attempt to effect personal service may result in undue delay, or is otherwise impracticable for any reason to serve the document personally, the court may make an order for substituted service of that document. But how will the court make the order? You have to apply to the court as plaintiff. You have to apply to the court and tell the court that you tried to serve the defendant, you couldn't find him, so the court should enable you serve him by substituted service. So if you look at Order 706, Sub 2, it says, an application for an order for substituted service shall be made ex parte and shall be supported by an affidavit stating the facts on which the application is founded. So when you are signing your affidavits, make sure that you have actually explained. So what we are saying is that if you are applying for an order for substituted service, state the facts on which the application is founded. So if you are drafting it, mention that you have tried on these occasions to serve him and you couldn't serve him. And how would you prove that one? Attach a search showing that the bailiff has gone there on these days to serve this person and it was unsuccessful, so that the court will know the factual basis on which you are coming for the substituted service. It's not enough for you to just go and stand there and say that you tried to serve and you couldn't work. No. Start a search where the bailiff it will be answered that the bailiff went there on these days and couldn't serve this particular person. So the court will know that this is what you are saying, and then that's what we'll use to grant the application. And remember, the application for substituted service will be ex parte, because you can't serve the other party. That's why you're coming to the court for the permission. So it cannot be on notice. That's why the application will be made ex parte. Now, under 7 Rule 6 sub Rule 3, substituted service of a document in relation to which an order is made under this rule is effected by taking such steps as the court may direct to bring the document to the notice of the person to be served. That's the whole reason of substituted service. That's why sometimes they can order that service in the newspaper, on WhatsApp, Facebook, anywhere that we think that when we serve you, and to bring it to your attention. That is where we have to serve you by substituted service. So there are a number of cases that are relevant for us to look at when it comes to substituted service. The first case we'll look at is the case of Combat and others versus Bediako and others, ex parte combat. Combat and others versus Bediako and others, ex parte combat. Reported in 1971, one Ghana law report at page 196 per Taylor G. This is what the learned justice said, and I quote. It appears to me that substituted service can only be resorted to where personal service cannot be effected for stated reasons. This means that if at the time of the issue of a writ for service within the jurisdiction, there could at law have been personal service of writs upon the defendant sought to have been served, but circumstances prevented such service being made, then substituted service of such a writ may be allowed. On the other hand, if at the time of issue of a writ, personal service could not have been made, then unless it's a case of evading service, substituted service cannot be ordered. In the case before me, since there was no address for service and the defendants may very well not be within the jurisdiction, personal service cannot obviously be made. Let me explain what this case of Combat and others versus Bediako is saying. That you can only resort to substituted service where personal service at the time you're issuing the writs, you could have actually served the person, but circumstances made it impossible for you to serve the person. That one, the court can order the person to be served by substituted service. But if at the time that you were commencing the action, there was no way the person could even have been served personally, maybe he's not even in Ghana at all. Not even in Ghana at all. So in that one, why do you go for substituted service? Because it was actually impractical. It was totally impossible for you to even serve him at the time that you were even issuing the writs. Another case is Dakar Limited versus Industrial Chemical and Pharmaceutical Company. This case addresses the issue of some lawyers applying to the courts to serve companies by substituted service. Meanwhile, we all know that if you go to the registrar of companies, registrar in our department, registrar of companies, you will see the address of every company over there. And remember, when we look at the modes of serving a company under section 291 of the Companies Act, one way is that you can even serve by registered posts. So if you can just go and post to the address, why should some people apply to the court to serve a company by substituted service? Because you can just go and post it to the address, and that will be deemed to be good service. So see what the case of Dakar Limited versus Industrial Chemical and Pharmaceutical Company Limited has said. This case is reported in 1981 Ghana Law Report at page 453, and I quote, "Substituted service is prima facie not intended to apply to a company. Substituted service on a company with a registered office is an abnormal process, and to say of a limited liability company that is evading service when it has a genuine office is to misconceive the nature of a limited liability company. It seems to me, therefore, that service of a document on a company ought to be effected by leaving the document act or sending it by post to the registered office of the company or the latest office registered by the Registrar General as the registered address of the company. I do not wish to be understood as saying categorically that substance service can never in any circumstance be ordered by a company. Every case must be decided on its own facts because the probable combination of circumstances may necessitate substituted service. Cannot be exhaustively anticipated by any prior formulation of a dogmatic principle. So it's telling us that since the company has an address that you can go and leave it at over there or send it by post to, how do you say that you will try to serve a company and you couldn't send the person? Even if when you go and there's nobody there, go and post it. That's what this case is saying. Dakar Limited versus Industrial Chemical and Pharmaceutical Company. If you read the book, very good book on civil procedure, titled Civil Litigation in Ghana in the High Court of Ghana, authored by Robert Smith Law Group, Bobby Banson as lead author. At page 7105, this is what he says, and I quote, despite the ratio of this authority, it is common practice for lawyers to apply to the court for an order for substituted service in the case of limited liability companies. It is the opinion of the author that this practice should be discouraged by the court, especially where under the provision of the Companies Act 2019, Act 992, promoters for companies must not only provide the unique digital address for their place of business, but also an email address and a telephone number for the purpose of service of such documents. He said that these days, even when you are incorporating your company, you are required to provide a unique digital address and also a unique email and a telephone number. So we can serve you in any of these means. Why should we go ahead and then say that we are going to substitute service, that we can't find a company when all these things are over there? So that is the case of Dakar Limited versus Industrial Chemical and Pharmaceutical Company. And those are the views too of the book titled Civil Litigation in the High Court of Ghana, authored by Robert Smith Law Group, Bobby Banson, lead author, at page 105. Now let's look at what we mean by affidavit of service. I've mentioned it over and over again. Now, affidavit of service under Order 7, Rule 9 of the CI 47, it says that, and I quote, subject to sub-rule 2, an affidavit of service of a document must state by and on whom the document was served. Again, I'm reading from Order 7, Rule 9 of the CI 47. Subject to sub-rule 2, an affidavit of service of a document must state by and on whom the document was served, the day of the week and the date and the hour on which it was served, where it was served and the manner in which it was served. So after the bailiff has gone to serve a document and then he is returning, like we mentioned, the bailiff must swear an affidavit informing the court that on this day you entrusted me with the writ of summons to go and serve this person, and I served him on this day, at this place, at this hour. So that affidavit of service must be on the docket of the judge, so that if the judge wants to find out whether any process has been served, we can refer to the affidavit of service. So anytime the bailiff goes to serve, he has to go and swear this affidavit of service so that he can inform the court about whether the process he was given has been served or not. Then Order 7 Rule 9 Sub Rule 2, an affidavit of service of a document sent by registered posts in accordance with Sub Rule 14B, Rule 6, Sub Rule 4 shall state by whom the document was posted, the registered number of the letter, the name of the person to whom the document was posted, and the address to which the document was posted. And the certificate of posting issued by the post office shall be exhibited with the affidavit. So that if you serve a person by post, you must attach all these things so that we will know that indeed this is how you serve the person by post. And this is the certificate the post office gave you to show that indeed this person was served. So an affidavit of service is what the bailiff will go and swear and depose to show that indeed when he was given this process, he went ahead to serve this particular person. Now, if you look at that 7 Rule 9 Sub Rule 3, it says an affidavit of service signed by the person who effects service shall, on production with proof of signature, be prima facie evidence of service. An affidavit of service signed by the person who effects service shall, on production with proof of signature, be prima facie evidence of service. So the affidavit of service shall, on production with proof of signature, be prima facie evidence of service. So once we see the affidavit of service that Kwame, the defendant, has been served, that affidavit of service will be prima facie evidence that indeed that defendant has been served. Then, what is this whole importance of service? Remember, if a person has not been served, you can't proceed against the person. You remember what happened in Barclays Bank versus Ghana Cables? If you haven't served the person, you can't proceed against the person. Everything and every step you take against the person will be a nullity. It will be as if you are condemning the person when he has not been given a right to be heard. Because you must serve him, let him be aware, then he can now be heard. That's why you've seen in this case of Orbitz. Orbitz is HOHRBITZ-AMPIM, AMPIM versus Attorney General. Reported in 2013-2015, one Ghana law report from pages 2 to 3. It was held that, and I quote, the principle was that no man had to be condemned unless he had been given prior notice of the allegation against him and the fair opportunity to be heard. No man had to be condemned unless he had been given prior notice of the allegation against him and a fair opportunity to be heard. That is what we mean by, that's the essence of service. It is important that we serve a person with the process, because if we serve him with the process, that is when that person can go ahead and then take a lawyer to also act on his behalf. But if you haven't served the person, then it will not be possible for you to proceed against the person. If you proceed, you risk that whatever you do would be a nullity. By way of recap, what we have done so far in this lecture is that we have said that service of processes. You must serve generally a document must be served on the person personally, unless the rules permit you to do otherwise. Again, under Order 7, Rule 1, the person who must serve a document must be the bailiff or a process server registered with the courts. But remember, we said a party may direct service. Now, remember we dealt with what will happen if the person you must serve personally refuses to accept service or obstructs or threatens you from serving the person. Order 7, Rule 3, Sub Rule 2, where personal service is hindered by threats, then you can leave the document as near that person as may be practicable. We dealt with service against partners under Order 6, Rule 3. We have dealt with serving a person with disability under Order 5, Rule 9, on how do we serve a person with disability. We said that it will be sufficient if we serve it on the father or mother or guardian. Remember, Order 5, Rule 9. We dealt with service on stools, that you can serve it on the occupant of the stool or the skin or any secretary, clerk, or linguist of that stool or skin. And where the stool or skin is vacant, on the regent or caretaker of the stool or skin. Remember, we dealt with service on companies. We dealt with the service of a person in prison or detention. That's Order 7, Rule 5, Sub Rule 4, where we mentioned that over there, then you can actually serve it on any person in charge of the prison or place of detention. So check Order 7, Rule 5, Sub Rule 4. We dealt with serving a minister of state in his or her capacity as a minister or the government department. We dealt with that one as well. Then you dealt with service on companies. Remember over there, we look at the Barclays Bank versus Ghana Cables, which was decided under the Old Companies Act. And you should see its applicability under the current framework. Then we dealt with substituted service under Order 7, Rule 6. What are the requirements? That 3 or more attempts have been made to effect personal service without success, and any further attempt to effect personal service may result in undue delay, or it's otherwise impracticable to effect personal service of the documents. Remember, I mentioned that under Order 7, Rule 6, Sub Rule 2, the application for substituted service shall be made ex parte. And remember, we look at the case of Dakar Limited versus Industrial Chemical and Pharmaceutical Company, which case frowned on the practice where you go for substituted service against companies because you can get the address from RGD or the Register of Companies and then serve them over there. Then I explained what an affidavit of service is as well. And I wrapped up by mentioning that until the person has been served, cannot proceed against that particular person. This is where we shall end this lecture on service, and we shall continue with service out of jurisdiction. Thank you.